All right, get this. Picture a legal showdown that sounds, well, kind of nuts. You've got a company famous for its underwear suing a company that makes steel. And the whole fight is over a single three-letter word. This is the story of one heck of a battle over a brand name.
Yeah, it's the first thing you're probably thinking, right? I mean, one company sells you something comfortable to wear, the other sells you stuff to build buildings with. On the surface, they have absolutely nothing in common. But, as we're about to find out, in the world of branding, things aren't always what they seem.
Okay, so let's meet the players in this little drama. On one side, you have Biswanath Hosiery Mills. They make LUX hosiery, and they've been a huge name for decades. On the other side, Micky Metals Ltd, a steel company that decided, hey, let's call our product LUX TMT. The products, worlds apart. But that name, oh, that's where all the trouble started.
Now, this wasn't just some friendly chat between companies. Oh no. Biswanath Hosiery Mills dragged Micky Metals to court with a really serious accusation, something called passing off. It's basically the legal way of saying one company is trying to piggyback on another company's hard-earned reputation.
And I mean, listen to the language from the actual legal complaint. The hosiery company was arguing that by using the name LUX, the steel company was totally trying to confuse people. They were trying to cash in on all the trust and the good name that the original LUX brand had spent more than half a century building.
So let's just quickly break down what passing off really is. Think of it like brand identity theft. It's when a new company uses a name or a logo that's so similar to a famous brand that you, the customer, might get tricked into thinking they're connected. You know, you might think, oh, cool, my favorite brand is making a new thing. That confusion is exactly what the law is designed to stop.
And really, this is what it all boils down to. The hosiery company wasn't just protecting a word. Nope. They were protecting decades of history, millions of dollars in advertising, and the trust they had built with countless customers. Their argument was that Micky Metals was trying to get all that benefit without doing any of the legwork.
So how do you even start to prove something like that in court? Well, to win a case like this, you first have to prove that your brand isn't just known, it's well known. The hosiery company had to convince the judge that LUX was a true household name with a deep and powerful history.
And boy, did they bring the receipts. Just look at this timeline. The brand was started way back in 1957. That is over 60 years of being on the market, building recognition and getting trademarks registered not just in one country, but all over the world. We're not talking about some flash-in-the-pan brand here. This was a legacy.
And to back all this up, they didn't just walk in empty-handed. They brought a mountain of evidence. They had witnesses come in. They had stacks of documents. And they showed proof of all their trademark registrations across different product types and in different countries. They were making it totally clear that their claim to the name LUX was legit, broad, and rock solid.
Okay, but I know what you've been thinking this whole time. Underwear and steel beams. They're in completely different universes, right? So how could anyone possibly get confused? It seems like that should be a slam dunk defense.
And that's the million-dollar question, isn't it? It's the puzzle at the heart of this whole case. It feels kind of weird. I mean, does owning a famous brand name give you a total monopoly on that word for any product anywhere in the world?
And the answer from the law is a big, loud yes. And yeah, it's kind of surprising. The court basically said that the power of a well-known brand is so strong that people might think there's a connection, even with totally different products. They might think, oh, the LUX company is getting into construction now. And it's that potential for confusion that really matters.
You know, this wasn't some radical new idea the court just came up with. The decision was built on a solid foundation of other big cases from the past. Rulings that involved giants like Sony and Mahindra had already set the standard that a truly famous brand name deserves really broad protection for the exact reason of stopping other people from riding their coattails no matter what they're selling.
So, the stage is set, right? You've got all the evidence, you've got the legal history. It was time for the final verdict from the Calcutta High Court. The battle of hosiery versus steel was finally coming to an end.
But, and this is a big but, the story takes a really weird turn here. After getting hit with this major lawsuit, Micky Metals just didn't show up. They never came to court to defend themselves. They just let the whole thing go, meaning all of the hosiery company's arguments went completely unchallenged.
So with such a strong case, and literally no one there to argue against it, the outcome was, well, pretty much a no-brainer. The court ruled completely in favor of the hosiery company, Biswanath Hosiery Mills, a total knockout victory for the original brand.
And listen, the court did not hold back.
They used some incredibly strong words to describe what Micky Metals did. They called it commercial piracy and misrepresentation. So in the court's eyes, this wasn't some honest mistake. It was a straight-up attempt to mislead people and steal another company's good reputation.
So what happened to Micky Metals? Well, the consequences were huge. First, the court issued a permanent injunction. That's a legal order saying they are forbidden from ever using the LUX name again, period. And second, they were ordered to tally up and probably pay back every single penny of profit they made using that name.
And just look at that date, 2009. The court ordered them to account for profits going back over a decade. That just goes to show you how serious the financial hit can be when you mess with another company's well-known brand.
Okay, so let's zoom out. Why are we talking about this case? I mean, why does this fight over underwear and steel actually matter to the rest of us? Well, it all comes down to the incredible value and power that the law gives to a famous protected brand name. This is the big takeaway, right here. If you manage to build a brand that everyone knows and trusts, the law sees that reputation as a real, valuable thing, like a piece of property. And it gives you some pretty powerful ways to protect that property from being copied or weakened, even by companies in fields you'd never, ever expect.
So at the end of the day, this ruling really just hammers home some fundamental rules of the branding game. It confirms that well-known brands get special treatment. It says that a company's good name is something you can actually protect in court. It makes it clear that stopping customer confusion is a top priority, and it sends a very loud message. You can't just piggyback on someone else's fame and expect to get away with it.
And it all leaves you with one big question to chew on. In today's world, with a million products all screaming for our attention, what is a name that people instantly recognize and trust really worth? Well, as this case shows, it's worth a heck of a lot. And it's definitely worth fighting for.